I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we are delivering the third part of our series on the EU Data Act, this time with a focus on how it impacts connected products. What's that, you might ask? Well, a connected product is basically anything with an internet connection, which seemingly means everything nowadays. As I mentioned in the prior episode, if you are picking this up and you have not heard our prior program that gives an overview of the Data Act and its impact on cloud computing, you might want to go back to that one. The Data Act is just so big that we had to split the discussion into 3 different episodes. One that provides an overview of the law and its implications, another that focuses on the impact to cloud-based services, and this one, which focuses on connected products and services. Check all of them out. They're really good conversations. And if you're looking to learn about the EU Data Act and how it may apply to your organization, this is a great place to start. With that, let's go ahead and discuss connected products. For that conversation, I've invited Christian Tinnefeld to the podcast. You have heard Christian on our prior episode, which gave an overview. He is a partner in our Hamburg, Germany office and spends his time advising clients on the GDPR, the AI Act, cyber, and now the Data Act. Christian, welcome to the podcast.
Hi, thanks for having me here.
So, Christian, on a prior episode, we talked a little bit about the broad application that the Data Act will have and the many ways that I think it will change how we do business, especially in some specific areas of technology and our specific product lines. And I think one of the areas that you brought up was around connected products. And that's where I wanted to focus today's episode, really trying to understand what is going to be the impact on these types of products and how can organizations start to prepare for those implications. So maybe taking a step back for a moment, what is a connected product under this law? And what are the types of companies that need to be concerned about connected products under this law?
Yeah, this is a good question. And it immediately leads us to why the Data Act is so important, because it's cross-sector. It's about cross-practice and industries. So practically each and every company that produces a product that is connected to the internet will be affected by this new law if they intend to sell their products to Europe, to the European market. Probably we start by way of example. So a connected product could be something like, obviously, a smartwatch, collecting information about the person who is wearing the smartwatch and transferring this data to a digital service like an app. But so this is B2C then, so business to consumer. But if you take, for instance, an industry like the medical device industry, with many gadgets and tools connected to the patient to collect patient data, this is also relevant or falls under the EU Data Act. If you look at the real estate industry, where you have many smart sensors included into smart buildings, like steering, the electricity, the sunshades, the lifts inside the building, then this is all related to devices, digital devices that are connected to the internet, so Internet of Things, and that collect, process data about the use of this digital device, but also about the environment, right? There are countless examples of these digital products.
Yeah, I mean, if it's as broad as saying that it's any hardware, any type of a physical type of product that is connected to the internet, that is a really broad definition. And if I'm understanding you correctly, it's not only B2C types of products that are connected to the internet, but it is also B2B products that are connected to the internet. And at least in my anecdotal experience, it's more and more difficult to find products that are not connected to the internet.
Yeah, correct. Absolutely. So if you look at, for instance, something that probably would not immediately come to your mind when you have a very high level view on this new law. If you take in agriculture a vehicle that is used for planting a field, and this is connected with by sensors that is collecting information about the soil, about the temperature, etc. So this is all digitalized if you want, and this would also be included or fall under the EU Data Act for all the data that is collected by these sensors. So product data and data that is generated if you use related services like a dashboard. If a company runs 10 vehicles and all these vehicles feed product data into a dashboard, a connected web application, then this information about the related service as well is considered to fall under the EU Data Act.
And so all of that data is going to be captured. So what types of entities, though, are also going to need to comply with respect to these connected products? Because I imagine you have, the manufacturers of the devices, you have the software publishers and creators who created the back-end software. Then you have the entities who are commercializing or licensing these products out. And then you have the users. And that's probably just a handful of the many types of entities that are interacting with these devices.
Mm-hmm.
So to whom does this law apply?
Yeah, so the Data Act, it implements certain stakeholders that play a certain role under the new law. And you named almost every one of them. So let's recap. So there is a company that is producing a digital device. This is the manufacturer. And this manufacturer can enter into a commercial agreement with either a consumer or a B2B customer under a purchase agreement or a rental agreement. Then obviously this manufacturer, who is at the same time a seller, falls under the EU Data Act, and I will tell in a second what this means here. At the same time, this manufacturer can cooperate with a contractor, probably a contractor that is running a certain application that is connected to the service. Then the data might flow to that software operator, and the software operator can become a data holder. In another use case, the manufacturer itself can be the data holder. What counts is the practical data flows from the connected device and the related service, and you have to identify this data flow and where the data resides. So this is the one part, the manufacturer / data holder, and the one party of the commercial agreement, if you want. Then there is the user, and the user, and this is relevant, can be an individual. So the consumer who is using a certain digital product, but most of the time, or at least in many use cases, there is a commercial user. So a company that is purchasing a certain product, for instance, in what I said, in the real estate industry. And then there is obviously as well a practical individual applying a certain device or gadget. So, and in this context, it sometimes is really tricky to identify who is the user in the legal meaning. Here, it would be the B2B company and not the individual pressing on a button to get a lift from store 1 to store 3, right? So, and to make it even more complex, can be another party, the so-called data recipient. And why is this relevant? The data recipient can be an individual again, or another third company who can be appointed to receive the product data upon the instruction of the user. What does this mean? In the pre-Data Act world, there was no legal assignment of the rights on the product data and related service data, but practically the right was just executed by the companies that produced the products and sold the products. And now the European legislator, what they do is a tremendous shift in this data economy. The legislator says, as of September 2025, the allocation of the usage right is taken from the manufacturers, data holders, and shifted towards the user. And the user can execute different rights. And we will dive into that in more detail, I guess, in a second. But to give a heads up to the listeners of the podcast, the user can ask him or herself to receive the product data and the related service data, but they can also instruct the data holder to transfer the data and to release the data to this data recipient. So you have the one part, data holder and manufacturer, you have the user, and you have the data recipient. And this is where different claims and different obligations and requirements from a compliance perspective evolve under the EU Data Act.
And my guess is then each one of those parties have differing obligations with respect to that. And maybe that's where I want to go next, because what I hear you saying, Christian, is that this law will have broad application to data, effectively any data that's created by a product connected to the internet. Then second, we are going to have broad application to the types of entities who are either collecting it or engaging in the commercialization of those products or using it, or even downward recipients of the information. And now then the key question is, okay, well, broad application, what do people need to know in order to comply with these obligations? So maybe if you can break down, the different categories of entities and where you see the main obligations coming from with respect to connected products.
Yeah, this is why I try to sketch the different stakeholders, because in my view, each company should now identify whether they are in a position of a user of a connected product, or whether they want to manufacture and sell these products and are in position of this manufacturer or data holder. Because depending of where you stand in the stakeholder and ecosystem, you have different perspectives to the EU Data Act. If you are a user, your role is quite comfortable in a way. So you know now that you have a new right to ask your contract partner to hand over certain data that is probably relevant for data analytics, for performance of services, for maintenance, for developing new supporting services and new goods. So this is comfortable. Nevertheless, you have to be aware of, okay, where are these digital products that fall under the Data Act, and can I make a commercial use of the data? And probably can I even commercialize this right that I have by sending the data or letting the data holder transfer the data to the data recipient. So this is then a commercial value, obviously. So this is probably the more comfortable role. And this is why I would tend to say, let's have a look first at the manufacturers and the data holders, because they are threatened to lose a right. At the moment, they are using the data for so many reasons, the one that I outlined, right? Data analytics, the improvement of their goods and the performance to improve the performance of their digital products, for the maintenance, predictive maintenance, for instance. So if they do not act, there is a certain fear that they lose their rights. If they do not have a look at their contracts, if they have already included in the terms and conditions, for instance, a right to use the data, then they might lose their legal entitlement as of September 25. And obviously, there's so much more. They can be addressed by their commercial users to hand over data, right? So they need to be aware, okay, what type of product data and related data is in my possession? So where does the data reside in my IT systems? Can I and how release this data upon request? And how do I manage all these user claims that might come along as of September? So there's quite a handful to consider for data holders and product manufacturers. If I want to put a slogan here, I would say the data holders and manufacturers, they have to prepare for identify their obligations and defend their rights, their interests. Whereas the users, they can prepare to identify the opportunities and make use of that. So it's an absolutely different mindset and view to the EU Data Act.
So, Christian, I know we talked about this on one of the earlier episodes, but it maybe help revisiting here because of the breadth of these requirements. Sometimes it can feel like it's overwhelming to understand the implications. At bottom, if I'm understanding the way the law is designed, is it's really trying to change the imbalance between the entities who hold the data because of the products that they provide and their ability of using that data versus the users who are effectively creating the data through either direct inputs or through the actual product. And so it's allowing, that imbalance for the users of the devices to gain more control about how that data may be used than perhaps they have now, where it's really the manufacturer or the publisher of that of those products for them to control how that data is being used. So if I'm getting that right, then is the issue that depending on where you sit, either as the user, the manufacturer, or somewhere else in that ecosystem, you need to have a clear idea of the data that's being collected and how that data is being used, where it's being used, and to where it's going in order for you to be able to not only understand what rights you need to that data, but also then to be able to figure out how to negotiate and obtain those rights through the commercialization of the product.
Yeah. Why is there this allocation to the user? So the European legislator, they had the idea to create a new data economy across the European market. So this is the European member states, but also the whole European economic area. By breaking up data silos and making more use of the data and starting a data flow so that there is a real trade in the data and that third parties that are not associated to this individual contract, they can ask for the data. For instance, like this data recipient can initiate a user to transfer the data to him or her. Why? For the purpose of developing ancillary services or improving products. So the idea is really to foster this data economy and to make use of the data that sits in silos at the moment. And if we talk to companies, how they should prepare and they should start with a Data Act project, then we always start by saying, identify the digital products and services that are in scope. So that sounds like very basic and very easy to do, but in fact, there are so many products and residing in a company and historic products that often the individual teams at the company, they do not really know where the data sits. So at the beginning, it's always good to do something like a data mapping exercise. And you remember this, we talked about this in data protection laws as well, when we talked about the implementation of the European GDPR, for instance. We always said, okay, know where your data is. And now this exercise comes up again in a different angle because it's not about personal data here. It can be, but the focus is on product data, on machine data, if you want, regardless whether this is a purely sensor data or associated to an individual. And starting with this data mapping would be good to understand where this data is. And then you have something like a contractual cleanup that you have to do. So you have to do your exercise to identify which type of terms and conditions apply, in which version, and so to identify whether this terms and conditions are prepared for the EU Data Act. And well, by no surprise, many terms and conditions aren't at the moment. And what is absolutely true is that this new use case that a user can ask for a transfer or a disclosure of their their data, this is not covered by most or 90% of the contractual terms of the companies at the moment. So this is a big exercise.
Right. So, I mean, if I'm getting that part right, whereas now the effectively users have much more control to not only request, but also to kind of direct how their data is being moved about. And it's also, if I'm also understanding what you're describing, Christian, is that the data that's subject here, right, is kind of a broad view of all of the data, but it's also kind of that machine generated data. And, we've gone through similar issues here in the United States, especially in the healthcare space around interoperability, creating the means by which you are data that is siloed in one particular healthcare entity can be able to be received and disclosed to somebody else. A important implication for that is that this data itself is not always, just think of it as benign information that is not really it doesn't have a commercial value. In fact, it's the opposite is the case. It oftentimes has a significant commercial value, in addition to the fact that that data itself may have important intellectual property and trade secrets embedded in it. In other words, if you're able to gain access to all of the user data, you're able to use that to reverse engineer how the software and product works, and thus be able to then undermine an intellectual property protection that a company has. So it ends up being quite important to, as you're saying, to not only understand all of the data, but to understand exactly what your risks are and rights are to that data and what you're trying to protect yourself against, especially when it's the case that almost every type of data may be disclosed to the user. And maybe that brings me to my next question for you, because one of the challenges to have your mind wrapped around how to do that is it's hard to understand how to do that at scale, and to do that in a way that you can repeat and do that in a systematic way, including to allow for subject matter experts for this particular product to come in and out, and to be able to allow for people to come in and out of organizations. And I think all of that translates back into another theme that is core to any type of strategy, and that's data governance. Data mapping, as you pointed out, as being a key component of a data governance program. Interested in your perspective of whether you agree, and then importantly, how do you see data governance supporting these larger efforts on complying with the Data Act and being able to obtain and maintain all the rights that you need with respect to the information collected through these connected products?
Mhm. I can't agree more. So this is a clearly a data governance exercise, what we are doing here. And what is relevant to know and understand for the individuals in the company who take the decisions, so the C-level, is this is a real project, right? It's not a lawyer's exercise. This is not about just revising a contract and amending some provisions. It's about bringing the right people in the company together. You mentioned the product experts. Obviously, this is all relevant that they contribute to the project. And because they are so, fed up in other stuff that they have to do, other projects, it's relevant that from the tone from the top, that the companies understand that this is really a core project that helps you gaining, in a best way, gaining new opportunities, and to help your company avoiding losing rights that you have at the moment. So this has a real business impact. It's not a lawyer's exercise, and it all starts with setting up the right setup, bringing the right people to the table. So when we discuss and cooperate with clients, it always starts with setting up the right project team. So there needs to be a stakeholder, can be a small group, can be an individual one, who takes care about that this project is moving, because there are so many action items and deliverables in the project. And there is, in the best case scenario, there is one person dedicated to the project who serves as our hub when we bring the legal expertise in and the recommendations, how other companies do this. But the project managers, they have to collect the right people. This is IT security. This is the products experts for the connected products, but also software engineers, because they are experienced with the related services. This is always a different group, right? You also have to include the data protection team and sometimes the DPO, because if you have a product that is used by an individual, no surprise, the machine data in many cases become personal data if you can identify the people that is using the data. Let's make an example. If you have a big company in logistics and they use vehicles, so trucks for delivering things, or you have a big warehouse with automated machines to pull things from the shelf and move it from A to B, then you could have the impression, well, this is very traditional and standard work, so this is not very digital, but obviously it is nowadays, right? And all these machines, they collect information about the engine, about whether a machine starts and stops, whether the battery used, and there are so many things. And the data is collected every second, every microsecond. And if you have a driver, let's say you have a forklifter and you have a driver that can be identified, for instance, if she or he is starting the engine in the morning and after their shift they turn off and someone else steps in, then this data is associated to an individual. And depending on the commercial use case of the operator of this logistics company, whether they want to have this information, who is driving the machine, at which time, it can be, or this product data can have or turn into personal data. So you need to bring the data protection guys in here as well. And then in the best case scenario, you start by making up a project plan. What do we need to take care about? So the first thing would be this data mapping. It can be then an in-scope analysis. So there might be historic services and apps, so legacy products that you do not want to use in the next upcoming years. So it might be relevant to consider of de-scoping them by saying, well, take the decision to turn them off, to get rid of the data so that it does not fall into the scope. This is one exercise. And then there are much more like this user claim management, like the terms and conditions review. And you also, unfortunately, I omitted this until this point in time. There is a transparency requirement, like with so many new European laws. You have to inform the users about the capabilities of the connected device, about the data that is being collected, about many, many different items. So if you look at this from a first glance, that might remind you of this privacy policy exercise that we have with websites or with employee notices, but it's absolutely different because it's looking at the machine data, and it's more sophisticated in a way because there are so many technical details that have to be poured into this, if you want, product notice. And that has to be kept alive. So if there's a change in the product, in the design, then you have to renew this. So in the end, you will have to make up your mind about various workflows in the company, with the different teams being involved. And you should consider whether you need new roles or at least new responsibilities in your organization for those people taking care of this. Because if you do not appoint a person, for instance, to update and collect all this information for the notices, well, no one will take care, and the notice is relevant to be in compliance with the law as of September 2025, right?
So, Christian, that sounds like a really long list of things that need to happen. And I agree with you. To bring order to all of that, that data governance program is really key. if I am in a business who has connected products and has a privacy team and data team that is frankly already overtaxed with all of the many other developments that are happening around the world that they are managing to, in addition to working on all of the fires that appear on a day-to-day basis. My question would be like, this sounds like a huge amount of work. And it
Mhm.
also sounds to me that I need to hire a bunch of people to do this, for which my guess is that budgets are not going to allow for that immediately. So maybe as we, wrap this installment of this Data Act series, from your perspective, are there any kind of immediate to-dos as clients and organizations are
Mhm.
looking to get their arms around the level of effort and frankly just where to begin on
Mhm.
this Data Act journey?
Yeah. Personally, I would start with the data mapping exercise. So this is probably, well, the most complex and burdensome thing to do, but there is a certain benefit from doing that, and there might be synergy effects. So what we learned at clients that took the effort, identifying where the data sits and how it can be pulled, and whether it's regularly updated and what format it is. We came across different teams at the organization who did something very, very similar. And this was a kind of data inventory, or sometimes the teams call it data catalog. And this is an exercise that companies do for a different reason other than the EU Data Act, but because they want to learn more about the data and how they can use it, how the data flows are in the company. So at a couple of clients, we came across that there is a team working on these data catalogs, data inventories already with a completely different perspective and task, if you want. And if you can make use of that, you can immediately cooperate internally and have a look from this EU Data Act perspective. And in very, very short sentences, how does this look like, this data mapping? So, well, you have to identify the different data fields almost and categorize them. So, for instance, you mentioned it in the beginning. It will be most relevant to identify, is a certain information about the product a trade secret? And if so, how can I protect it? The Data Act, because of the purpose to make the data, keep the data rolling and make it available to many stakeholders, there is no focus on the protection of trade secrets. So you have to identify which data is really a trade secret, and if you can protect it for from another law perspective. So you have to find a reason why to not to disclose the data. And this can be, for instance, if this certain data is relevant for the security of the product. So data that is processed for security reasons, this can be exempted from the disclosure of the product data. And this is a really important exercise. So for instance, another reason not to disclose data is content. Content is not product data, so it can be taken away from the disclosure. So you give it another tag, right? You have a tag for the data trade secrets, a tag for the data security relevant, a tag for content, and then what is in the focus of the data is the raw data, the raw machine data. Meaning, if you take this data, analyze it, put another algorithm to it, invest in transforming the data to so-called derived data, then this derived data where you as a company made an investment in, this is excluded from the Data Act as well. So having a very close look at which type of data is sitting where in your organization and IT system, this is key for this whole Data Act and EU Data Act implementation exercise, and all the rest will follow from that. So I would start with that. And if and you're absolutely right in saying that the internal teams are often overwhelmed with what they have to do anyway. So Data Act, AI Act, so all the other security laws and cybersecurity laws. So the companies might to consider whether they want to get external support for that. And there are many data analytics companies that specialize on this EU Data Act exercises and steps.
Yeah, and maybe if I can add to that, look where the synergies lie between the actions that they're already undertaken to comply with a bunch of other laws and obligations with, what's going to be required here. So in other words, as you're thinking about, let's say, data mapping as an example, data mapping comes up over and over and over again as organizations are looking to comply with different types of obligations. And it's effectively essential. And oftentimes it can be an area where organizations get it quite wrong when they are too myopic about what they're trying to accomplish through that data mapping. In other words, if they are looking at things of saying, I'm only going to map data to comply with cross-border data transfer rules, and that's the only way I'm going to look at it. I'm only going to look at it in the United States, and I'm not going to cover other areas of the world. You miss an opportunity to essentially capture some of those learnings, and then be able to use those learnings to make life easier when you are going through what is going to be a significant effort to comply with and to be able to position your data use activities around the EU Data Act.
Absolutely. It requires a holistic approach and look at the data that you have as a company. And just to give another example, because it's sometimes that abstract for probably the listeners who have not dived into much detail with the data mapping exercise and data governance. We talked about de-scoping products and services. If you have a legacy product that is not intended to be sold on the European market in, let's say, late 25 and going forward. Obviously, it's worth considering whether it falls under the Data Act still, or whether it can be put away in your view of the EU Data Act implementation. If you have then a related service like a mobile application steering the product, it's worth considering de-scoping this as well. And what do I mean by de-scope? And now there comes the synergy that you just mentioned. From a data protection perspective, it's obviously relevant not to store data that is not used anymore or not required anymore. So the data minimization principle and the storage limitation principle. So this exercise will help you avoiding other non-compliance risks, like storing and using data for too long or forgetting it in data silos. We've seen across Europe quite a couple of proceedings where companies were sanctioned by the competent data protection authority for exactly that, for having too much data from ancient times, right?
Yeah, 100%. Well, Christian, maybe that's a good place for us to pause this episode. As for the listeners who are interested in the EU Data Act, as a reminder, we have at least three, maybe even we'll do more, but at least 3 episodes that are really tied into this important development. So if you enjoyed this episode, please check out the other ones that give an overview of the EU Data Act, and also one that's focused specifically on the implications for cloud, which, as you may recall, is just as significant as it is for the connected products. So with that, Christian, really appreciate your insights and sharing your expertise with our audience. And I'm sure we'll be speaking a lot together about how organizations are rising to the occasion created by the EU Data Act.
Yeah, thank you.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.